Welcome to part 4 of working with electronic documents. This is the fourth and final video in the series which has been prepared for LEAD, the Legal Education Division of the Law Society of South Africa. Part 1 was a very basic look at electronic document formats and the benefits and pitfalls of working with electronic documents. In part 2 we discussed encryption, what it is, why we can trust it, and what it can be used for. In part 3 we discussed what a certificate is and how the issuing of certificates is regulated by the ECT Act. In part 4 the focus is on how encryption can be used to ensure confidentiality and how to add an electronic signature to a document. Encryption is at the foundation of electronic document security. In this video we discuss two applications of cryptography: crypto confidentiality and crypto signatures. Encryption can be used to ensure the confidentiality of a document. Only the intended recipient has the key to unlock the encrypted document. No one else can read the document, and we saw in part 2 that it'll take millions of years to try and unlock the document with the correct key by just guessing random keys. This slide uses a physical analogy to try and explain the difference between protecting a document with a password and encrypting a document. When a document is stored on a server, which is password protected, it is similar to locking the document in a strong container, such as a safe. The document inside the safe is still fully readable. The protection is as good as the strength of the container. When the document is removed from the safe, the protection is gone. Encrypting a document, on the other hand, changes the document itself. It's more like shredding a document and mixing up the bits and pieces based on a pattern or key. For this analogy, we have to imagine a device that performs the opposite of shredding a document. With the right key, it can assemble the mixed bits and pieces of a shredded document again. The document can be sent securely to a recipient without having to lock the document in a strong container. This can be done by sending the mixed bits and pieces, knowing that no one without the key would ever be able to put the document together again. The point of this analogy is that encryption changes the document itself. After encrypting a document, it can be sent over an insecure communication channel without the content leaking out. We have looked at how encryption can be used to provide confidentiality. Let's now have a look at how encryption can be used to add a signature to an electronic document. A secure signature is a mark on a document that only the signatory could have made. The signatory uses his encryption key to add this mark to a document by encrypting a summary of the document and appending it at the end. Only the signatory has the ability to make this mark. No one else could have marked the document in the same way. Without the key, it will take millions of years to try and mark the document in the same way. The signatory cannot deny having signed the document because he is the only person with the key and therefore the ability to encrypt the document summary. The signature is based on the content or summary of the document. If the content changes, the summary changes, and therefore the signature itself will change. The signature is not valid for any other document or any changes to the signed document. A wide range of handmade marks are accepted as signatures on paper documents. It should be clear that not all handwritten signatures are equally secure. An X made with a pen when signing a paper document does not include the identity or name of the person as part of the signature. It is also not so easy to distinguish one person's signature from that of another person just by inspecting an X. It's also not too difficult for someone else to make a similar looking X. It's important to understand that signatures that are added to an electronic document are also not equally secure. Signatures added to electronic documents may include a name typed at the bottom of an electronic document, or email message for that matter, a scanned image of a handwritten signature pasted into a document, a crypto signature, which uses a key to encrypt a summary of the document where the certificate with the key could have been obtained from any certification authority, and a crypto signature, which uses a key to encrypt a summary of the document where the certificate containing the key was issued by a certification authority accredited by the SA Accreditation Authority. This last option is what the ECT Act calls an advanced electronic signature. It should be clear that an advanced electronic signature is much more secure and certain than a signature made by using any of the other options. Let's have a look at how the ECT Act defines electronic signatures. According to the Act, electronic signature means data attached to, incorporated in, or logically associated with other data and which is intended by the user to serve as a signature. This definition clearly includes the option of typing a name at the bottom of an email message, as well as pasting an image of a handwritten signature into an electronic document. When the ECT Act talks about an advanced electronic signature, it is defined as follows. An advanced electronic signature means an electronic signature which results from a process which has been accredited by the authority as provided for in Section 37. The criteria in Section 38 is the important part. It says, the accreditation authority may not accredit authentication products or services unless the accreditation authority is satisfied that an electronic signature to which such authentication products or services relate is uniquely linked to the user, is capable of identifying that user, is created using means that can be maintained under the sole control of that user, and will be linked to the data or data message to which it relates in such a manner that any subsequent change of the data or data message is detectable, and is based on the face-to-face identification of the user. Obviously, signing with an advanced electronic signature is much more trouble than simply using an electronic signature. So, when can electronic signatures be used, and when do we have to use an advanced electronic signature? The rule is simple. When the law requires that a signature is needed, such as on a trust deed, an advanced electronic signature must be used. In all other cases, a simple electronic signature may be used. Let's read what the Act says in Section 13. Where the signature of a person is required by law, and such law does not specify the type of signature, that requirement in relation to a data message is met only if an advanced electronic signature is used. Subject to subsection 1, an electronic signature is not without legal force, and effect merely on the grounds that it is in electronic form. How can we be certain that a name typed at the bottom of an email message can act as a signature? Well, there is a Court of Appeal ruling that helps us interpret the ECT Act. In a court case of Spring Forest versus EcoWash in 2014, the judge ruled in paragraph 27 of the judgment that the Act describes an electronic signature, which is not to be confused with an advanced electronic signature, as data attached to, incorporated in, or logically associated with other data, and which is intended by the user to serve as a signature. Put simply, so long as the data in the email is intended by the user to serve as a signature and is logically connected with other data in the email, the requirement for an electronic signature is satisfied. This description accords with the practical and non-formalistic way the courts have treated the signature requirement at common law. The ECT Act is very specific about signing electronic documents, but silent about communicating electronic documents. This leaves the question open as to which communication services are suitable for sending and receiving electronic documents. Whereas it seems that most users realize that Facebook, Twitter, and WhatsApp may not be the best way to send sensitive or important documents, it seems that very few people are aware of the fact that services such as Dropbox and email are also not a good way. In emails, large attachments are often stripped off. Important documents are mixed with spam and junk mail. Important documents may be filtered out by the spam filter. How often have you told someone that you have not received an email message just to find it in your spam folder later on in the day? Email has no trusted delivery receipt. Email does not form a good archive of documents that have been sent or received. Standard email has no guaranteed confidentiality, and standard email has no guaranteed integrity. In recent years, there have been more and more cases where intruders have intercepted email messages and changed banking details, resulting in payments being made into the wrong bank accounts. Part of the problem is the lack of security provided by email. At the time of making this video, the understanding is that the loss of these funds is not covered by the Attorney Fidelity Fund. So how about using services such as Dropbox or Google Drive to deliver electronic documents? Well, as long as there is no sensitive or personal information in the documents, it may work. But the moment the document includes personal information such as ID numbers, addresses, and so forth, we have to keep in mind what the POPI Act says. The POPI Act requires that a responsible party, this assumedly is the party sending the document with personal information, must, in terms of a written contract between the responsible party and the operator, assumedly Dropbox or Google in this case, ensure that the operator which processes personal information for the responsible party establishes and maintains the security measures referred to in Section 19. The operator means a person who processes personal information for a responsible party. We would like to leave you with one last thought. When using documents to add trust to the legal processes, it's important to have certainty when exchanging these electronic documents. This includes certainty of the sender's identity, the receiver's identity, the delivery confirmation, and certainty of the contents of the document. This was part 4 in the series of 4 videos on working with electronic documents. Part 1 touched on the most basic concepts of working with electronic documents. In Part 2 we mainly discussed encryption, how it works and why we can trust the security it provides. Part 3 discussed certificates and the role of the South African Accreditation Authority. This fourth part focused on how electronic documents can be signed.